under certificate of identity. The grounds which our application is premised on are on the face of the motion and the supporting affidavit by Gamaliel Anamanja, sworn on the 14th of February 2022. I will proceed, Your Lordship, to analyze the grounds the authorities in support of our application for empaneling of an even number of judges to hear and determine this matter pursuant to Article 165(4) of the Constitution. Your Lordship, in determining whether a matter raises substantial question of law for the purposes of Article 165(4) of the Constitution, the following test is to be applied. Judge Odunga in Philip K. Tunoi, this is the authority is listed as number 2 in our list of authorities that we find. Judge Odunga in Philip K. Tunoi and another versus Judicial Service Commission and another cited the Indian case of Chunilal Mehta versus Century Spinning and Manufacturing Company, where substantial question of law was defined as follows. 1, a substantial question of law is one which is of general public importance. 2, one which directly and substantially affects the rights of parties. 3, one which is an open question in the sense that the issues have not been finally settled by the Supreme Court. 4, one where the issue is not free from difficulty or which calls for discussion of alternative views. Your Lordship, this case raises questions of law as well as matters of great public interest and importance. Some of the issues which the applicant has identified are as follows. 1, whether the first defendant observed the national values and principles of governance set out in Article 10 of the Constitution in the manner he lists out the assets of Mumias to the 6 defendant respondents. Lordship, Article 10 of the Constitution provides that national values and principles of governance not only bind public officers and state organs, but also persons whenever they make or implement public policy decisions. Whereas the dealings of the first and the second defendant with the company is a private affair, the process of receivership, particularly where he was appointed as an administrator, is a matter of public interest. This is so because the rights of parties, e.g., the rights of third parties, example, unsecured creditors, sugarcane farmers, employees of the companies are involved. 2, this case, that is before court, raises a question as to whether the first and the second defendant were bound by those constitutional principles of transparency and accountability that require the receiver and or administrator to secure the best possible price for the assets and property of the leased company. Article 27 of the Constitution on equal protection of the law, the Lordship. This case has raised a question as to whether the receiver manager leased the property of Mumias for a period of 20 years to only settle the debt of one creditor, the second respondent, who has a debt of 2.6 billion. The other creditors like Moko, who are owed over 3.7 billion, will not get anything in the duration of the 20 years. And yet, there are probably better offers that were on the table that would have settled all these debts within the shortest possible time. The respondent, it has been stated in this case, took a deal that would prolong the time to the exclusion of other creditors. This case and the application is of general public importance, and the decision to be made by this court will be precedent setting in the evolving principles of the law of insolvency, which now states that an administrator, when exercising such functions, also serve the public interest and not merely financial interest of the creditor. The Supreme Court stated in Hermanas Philippus versus Giovanni, that is the third authority in our list of authority, that the term of general public importance is what amounts to public interest. This is concerning of all members of the community or state. The second on the second test as to whether the case raises a substantial question of law is whether it is one which directly and substantially affects the rights of parties. Your Lordship, this case concerns the leasing of assets of Mumias that owes over 30 billion in debt. And if there is a real possibility of realizing the creditor's debt as soon as possible and reviving the operations of the company. Your Lordship, these debts are owed to secured creditors, unsecured creditors, sugarcane farmers, and employees. And therefore, the case raises substantial question of law that will directly and substantially affect the rights of this party and the communities living in Kakamega. The second ground upon which our application is premised on, Your Lordship, is that the decision of this court in insolvency petition number E004 of 2019 that was delivered on the 19th of November 2021 is one of the troubled issues in this matter. This is so because one of the issues that is before court for determination is that this court appointed the first defendant respondent as an administrator, a position that was conflicting with his earlier appointment as a receiver manager by the second defendant. The case before court is that he disregarded his appointment as an administrator and proceeded to lease out the assets of Mumias on the basis of his appointment as a receiver manager, while selectively picking and relying on parts of the judgment that this court allowed him to proceed with the leasing in the manner that he did. This case seeks to challenge the illegal acts and or omissions committed by the first defendant in the leasing of the assets of Mumias to the sixth defendant respondent. It is intriguing that the first defendant finds comfort in the judgment of 19 November 2021 as a basis for those illegal actions and or omissions. He has specifically stated so at paragraph 24 to 26 of the supplementary replying affidavit sworn on the 11th of February 2022. At paragraph 24, he states that at paragraph 129 of the ruling delivered on 19th November 2021 in Nairobi Insolvency Petition number E004 2019, United Associates and Advocates versus PB Rao and KCB Bank, hereinafter referred to as the insolvency petition, produced at pages 7 to 72 of the exhibit annexed to the affidavit sworn on 19th of January 2021, that the court directed me to guard against the violation of the Competition Act and to guard against the monopolistic tendency in the proposed listing. At paragraph 25 of the said supplementary affidavit, he says that the judge's exact words were that the court, being mindful of all the foregoing, it will permit the proposed listing, but direct the second respondent that in doing so, he should guard against the violations of the Competition Act 2010, and that he should guard against monopolistic tendencies which may lead to breaching of the law. At paragraph 26, he says that that imposed on him an obligation to, among other things, carefully consider in evaluating bids whether there was a risk of creating monopolistic tendencies. Your Lordship, Article 50 of the Constitution, right to a fair trial, it envisages an independent and impartial hearing. The issues of impartiality is being brought to question because of the previous decision that was made by the court in insolvency number 004 of 2019. We submit that having looked at the pleadings in the insolvency petition 004, the ruling of 19th November, the issue of Competition Act was not pleaded and or referred, but nonetheless, no basis as to why the same was. But nonetheless, there was no basis as to why the same was introduced. The Lordship, the first defendant, has also been accused in this case that he was biased in the manner that he analyzed or failed to take into account the technical or important issues from a competition law perspective. He is also accused of having no legal mandate or professional expertise to conduct any assessment or finding of a market dominance as he purported to be. This court will be called upon to determine whether the judgment of 19th November 2021 permitted the first defendant respondent to commit the illegal acts and or omissions stated here. And in the circumstances, we submit that it would be better that the Honorable Court is shielded from undue pressure and or embarrassment of being referred to its own decision, which is